My name is Lawrence Wood. I'm the director of the Housing Practice Group here at LAF, and this is for the new attorney training. All right. So what we're going to cover today, I'm going to talk about my practice group and what we do. I'm going to talk about the subsidized housing programs. We focus primarily on helping residents of subsidized housing. I'm going to talk about the eviction process and the importance of eviction defense, which compromises more than half of what we do. And then I'm also going to be talking about what we call silo busting, which is a term I really hate, but it's used to describe this process where we try to get members of different practice groups to collaborate with each other, because very often a client comes to us and they have more than a discrete legal problem in just the housing area. They might have a problem in the consumer area. They might be a victim of domestic violence. And so we try as much as possible to collaborate with each other when necessary, provide a holistic approach to service. So the Housing Practice Group, as I said before, I'm the director. We have 4 supervisory attorneys. Michelle Gilbert is our point person. She is the person that you would contact if you are representing a client in your practice group. They also have a housing problem and you want us to get involved in the case. Michelle is the person you would contact. Denerica Brooks, Nehal Lal, Tim Huffman. Tim Huffman was my supervisor years ago. Hi, John. And he is now semi-retired. He is working 60% time, and he runs our eviction help desk down in Markham, which is the 6th municipal district. And they see down there the greatest number of eviction cases aside from the 1st municipal district at the Daly Center. So Tim is supposed to be working just 60% time, but he really works pretty much full-time. When he was a full-time attorney, he worked about 80 hours a week. Now that he's a part-time attorney, he works about 55 hours a week. The staff attorneys that we have, you may have met some of them already: Lawrence Wagner, Sarah Song, Jackie Koryath, who's on maternity leave right now, Jessica Kalmowicki, who just walked into the room. Somewhere, there she is. Jessica's actually not very new. She started at LAF 17 years ago, left, came back, left, came back. She's back for the 3rd time now, and we're thrilled to have her. Veena Gursahani, who's the senior litigation associate until recently at Sidley Austin. And Shayna Kleist, also one of our 3 new attorneys who just started. Shayna, where's Shayna? There's Shayna. Okay. We also have a housing advocate, Matt Linus, who does a lot of work, especially on behalf of clients who are HIV positive or have AIDS. So what we do, eviction defense, which I'm going to be talking about in quite a bit of detail. Again, this is primarily in the context of subsidized housing, just because there's so much at stake in those cases, and it's not that we don't think that unassisted housing cases are important, but there's just much more involved in the subsidized housing cases, much more to save, and so that's where we focus our resources. We also take cases to preserve what's called tenant-based rental assistance under the Housing Choice Voucher program, and I'm going to be describing that program in detail as well. We will represent voucher holders not only in evictions, but when the public housing authority that administers this rental assistance program moves to terminate the family's assistance under the program. We also force landlords to make necessary repairs. We used to do a lot more of that work when we had a Skadden Fellow, Eli Wade Scott, whose project was devoted to filing these cases, to taking an affirmative approach to doing those cases. It's harder for us to take a lot of those affirmative cases right now. For the most part, we will try to address conditions when we're representing a tenant in an eviction case. Very often, if they're facing eviction for non-payment of rent, we have a defense. It's called a warranty of habitability defense, in which we're arguing that the landlord's failure to make necessary repairs has reduced the value of the apartment by an amount that exceeds the rent due. But it's also very important to take these cases, file these cases, take an affirmative approach, because so many units have not been properly maintained, so many rental units in Cook County. In fact, when Eli Wade Scott came to work for us and got his Skadden Fellowship, when we were putting his application together, we were focused on an article that showed that more than half of the units that are assisted under this, the Housing Choice Voucher Program, in Chicago fail what are called housing quality standards inspections after the first year. We also represent clients who have been wrongfully denied admission to subsidized housing. We help families that need transfers or need to be relocated when they're subsidized housing residents. We also do as much impact work as we can. We're involved in initiatives to improve the administration of justice in the eviction courtrooms. There are two main initiatives that we're working on right now. One is to get electronic recording devices in all of the eviction courtrooms in Illinois. When I started 27 years ago at LAF, there were court reporters in all of the eviction courtrooms, which was great. So you had a record of what went on, and it made it easier to challenge judges when they either made a ruling that was against the manifest weight of the evidence or incorrect as a matter of law, or frankly when the judges said something inappropriate. And that happened all the time. Unfortunately, because of funding issues, there was no more money to pay court reporters to be in the eviction courtroom. So right now, if you want to have a record of what goes on, you have to pay for a court reporter to come with you to that one proceeding. And that's just not efficient. Also, it's very hard now when a tenant comes to us and says, well, I was in court and this happened, and we think, well, that's wrong, and we want to challenge it, but we have nothing to really establish that what the client said happened actually did happen. So it's very important to have a record. Just to go back a little bit to inappropriate comments that judges make, it's very important to keep a record of this because judges can behave inappropriately. They can intimidate pro se litigants. They can make comments that are inappropriate sexually. We've seen that happen a lot. Just to give you one example, there's a former LAF attorney. He's now a judge named Dave Harris. He's in domestic relations. But he appeared in eviction court once on behalf of a tenant who was a quadriplegic. And he brought a motion for summary judgment. He appeared in court for the hearing on his motion. And he said to the judge, well, Judge, as you know, my client's paraplegic, and his client was not in the courtroom, thank God. And the judge did not know that because the judge, like many eviction court judges, had not read the briefs before the hearing. And he said, and this was at a time when there was a court reporter in the room, he said, client's quadriplegic, said off the record, I've got a joke. And so this was not recorded, but he then told his quadriplegic joke, then went back on the record and presided over the hearing. So it's really important to make sure that we do have electronic recording devices. And we're working with a firm, DLA Piper. We're also working with the Chicago Appleseed Foundation on this initiative to get the recording devices in the eviction courtrooms, which will make it much easier for us to do our jobs. We are also working on an initiative to create plain language forms for all the eviction courtrooms. Right now, the eviction forms are full of legal terminology that no layperson would understand. And so we're working with the Illinois Supreme Court's Access to Justice Commission on creating plain language forms. One of these forms, actually, is going to be required by a provision of the Eviction Act. And this is going to become effective January 1st, 2018. And we have just actually created that form. And that form is the eviction order. Right now it's called order for possession. And again, you would not understand it if you read it. Many lawyers wouldn't understand it. And the problem is that, and I'll talk about this in more detail in a little while, a lot of tenants would sign these forms not knowing what they were signing. So we're trying to create a form that's much simpler and will ensure that when a tenant signs the eviction form, they understand what the effect of that form will be. We represent tenant groups in an attempt to have an impact on not just an individual client, but on a broad group of individuals. As you know, the LSC regulations that we labor under prevent us from filing class actions, but fortunately, the LSC regulations identify tenant organizations as an individual client. So we can represent them when they say we have a problem that we know is affecting all public housing residents or all voucher holders. And so we can go into court and represent them. We did that recently in a case that I mentioned one of our new attorneys, Vinegar Sahani, when she was at Sidley, she helped us on. This was on behalf of a tenants organization, the local advisory council that was in charge of the Cabrini row houses. And in that case, there were 568 units. I don't know if you all know where Cabrini is and where the row houses are located. They're located in an incredibly expensive area of Chicago. In fact, if you go out there right now and look at the row houses, it's really striking because you'll see these row houses, many of which have been boarded up. They're uninhabitable. And they are 1 block away from $500,000 or $1 million condos. I mean, everybody wants to live in that area. So what had happened is CHA had initially said, we're going to rehab these 568 row house units, and we're going to maintain them all as 100% public housing. And then they reneged on that promise, and they said what we're going to do instead is we're going to turn this into a mixed income development, which meant that only 30% of the units would be set aside for public housing. And so on behalf of the LAC, we went to court and we filed a fair housing action claim against them, saying that essentially the effect of their decision would be to force a lot of people who could have been living in that area to get vouchers and go into economically depressed, racially segregated areas. And the Chicago Housing Authority has a duty to affirmatively further fair housing. And so we said that their decision to turn the row houses into a mixed income development would violate their duty to affirmatively further fair housing. And that litigation went on for 2 years. It went up to the Seventh Circuit, and then there was a settlement agreement. And the settlement agreement was really terrific. And and in the settlement, CHA agreed to bring 1,800 units of subsidized housing into the near north area, and also to have more public housing and affordable housing in the Cabrini row houses. So it'll still be a mixed income development, but there's going to be much more subsidized housing in this near north area, which is what we call an opportunity area, because it's close to good schools and to public transportation and to good jobs, and that's where we want subsidized housing residents to be living. And then, of course, we can also do impact work through appellate cases. So, it's kind of hard to identify which case is going to become an appellate case when the client walks through the door. But if you can take a case up on appeal and then actually get a published decision, well, that's going to have a huge effect. Unfortunately, in Illinois, you don't know whether you're going to get a published decision even when you take a case up on appeal because of this horrible rule that's called Rule 23, Illinois Supreme Court Rule 23, which provides that some appellate decisions are actual decisions that will be published and have precedential value, but most of them come out as what are called Rule 23 orders. They are just as long as decisions. They can be just as well-reasoned as any other published decision, but they have no precedential effect. In fact, if you cite a Rule 23 order in support of an argument that you're making, you can be sanctioned. So I don't understand the rule. John, I don't know if you have any insight into why we have that rule. Zero insight John has into that. But that...
only true for a lot of things.
I'm sorry?
Zero insight on that.
So that's another way that we can have an impact beyond just an individual client. So why focus on subsidized housing? In the subsidized housing programs, the family will pay a reduced rent equal to a percentage of the family's household income. And in most cases, and a major exception is the Housing Choice Voucher Program, which is a tenant-based assistance program that I'll discuss in a little while, the rental assistance runs with the unit. So if someone is evicted from subsidized housing, they are going to lose not just their apartment, they're going to lose the rental assistance that runs with their unit. And if they're financially eligible for subsidized housing in the first place, then by definition they can't afford market rent and they will likely become homeless or they'll have to move into an overcrowded, poorly maintained unit. In most cases, again, the Housing Choice Voucher Program is the exception. An endless lease agreement renews itself at the end of every term unless it is terminated for good cause. So that's why there's so much at stake in these cases, and that's why we focus on representing subsidized housing residents. So I want to talk very briefly about the different subsidized housing programs, just so you have a very basic understanding of it. One of the largest public housing, subsidized housing programs is the public housing program. Public housing is owned by public housing authorities, PHAs, like the Chicago Housing Authority or the Housing Authority of Cook County. Again, in these cases, the rental assistance runs with a unit. You've got an endless lease that may not be terminated except for good cause. And one great right the public housing residents have that other residents do not have is they have grievance rights. If the public housing authority takes some adverse action against them, in most cases, the resident will have a right to request a grievance. This can be especially important in the eviction context. The termination notice in public housing must inform the family of the right to a grievance hearing. There are some exceptions to this rule. If the family is facing eviction for a felony or eviction for drug-related criminal activity on or off the premises, or if they're facing eviction for a crime that threatens the residents or management's health or safety, they are not entitled to a grievance hearing. That doesn't mean they have no rights. They're still entitled to go to court. The Public Housing Authority still has to file an eviction action against them, and then in court they can raise any defenses. But it's nice if they have this extra step to challenge the termination of their tenancy through a grievance hearing. Let's talk a little bit about this exception. Evictions for drug-related criminal activity on or off the premises. This means that if, let's say, an 18-year-old household member is arrested in California for possession of one joint, okay, and the Public Housing Authority finds out about it, they can evict the entire family, okay? Doesn't matter where the drug-related activity took place. It doesn't matter how insignificant the drug-related criminal activity was. It can jeopardize the entire family's tenancy. Now, it's not an open and shut case. There are a lot of defenses that the family may be able to raise, but that's a pretty harsh sanction. And actually, this issue went all the way up to the Illinois Supreme Court in 2002, I believe, in a case called Rucker, in which the U.S. Supreme Court said, public housing lease agreements do have to have a provision that essentially holds the residents strictly liable for the actions of their household members and guests. Fortunately, before Rucker came out, Rich Wheelock had, and Rich Wheelock is our director of advocacy, my boss, one of my many bosses, and Rich had convinced CHA to include in its lease agreement a provision that allows residents to raise what's known as a knew or should have known defense. So if the head of household is facing eviction because a household member or a guest committed a crime, the Public Housing Authority, CHA, does not have to establish in court that the head of household knew the crime would happen or participated in the crime, but the head of household may raise as an affirmative defense that she did not know or have any reason to know that the crime would occur. And if she prevails on that defense, she wins the case. That's an incredibly important provision, and it actually distinguishes Chicago public housing residents from just about every other public housing resident in the country. The nice thing is that after Rucker, CHA kept in that provision, and we've relied on it a lot. And it's good because we support CHA's effort to reduce criminal drug-related activity at its developments, but we don't want to see innocent people evicted during such an initiative. At one point, a few years ago, Jessica, I can't remember if you were around when this happened, CHA decided that they were going to remove that lease provision. And I remember sending out an email to the Housing Practice Group saying, well, it was nice while it lasted, but we have no legal basis to argue that they don't have a right to do this, given Rucker. And Lizzie Rosenthal, former supervisor in the Housing Practice Group and someone I supervised, sent back a reply all email saying that she was going to smack me upside the head for giving in so easily. And she said, we have to launch a campaign, focus attention on this issue, explain why even though CHA has the legal right to take this action, they shouldn't do it. And so we did that. Lizzie really led the campaign. There was a lot of media attention. There was a public hearing. We were busing residents in to this hearing where we all got 2 minutes to address the CEO of CHA. And CHA backed off. And they said, okay, we're going to keep this provision in the lease agreement. If the family, in the eviction context, submits a timely request for a grievance hearing, the lease remains in effect pending the resolution of the grievance process. That is especially important, as I'll discuss in a little while, if the tenant is facing eviction for non-payment of rent. Because if a public housing resident is facing eviction for non-payment of rent, they owe the rent, they can't pay it before the termination notice expires, they may be able to preserve their tenancy by filing a Chapter 13 bankruptcy petition. But this petition has to be filed while the lease remains unexpired. And the Seventh Circuit says that a lease expires when it's terminated. So if you can keep the lease agreement in effect pending the resolution of the grievance process, bankruptcy continues to be an option that you might want to take advantage of. All right, moving on to Section 8, project-based developments. These developments are owned by private entities that have contracts with the U.S. Department of Housing and Urban Development. They use a HUD model lease. So very often if you're looking at your client's documents and you see this HUD model lease, then you know they're in a Section 8 development as opposed to public housing or some other type of subsidized housing. The rental assistance, as with public housing, runs with a unit. Again, you've got an endless lease that may not be terminated except for good cause. There are no grievance rights, unfortunately, that residents of these developments can take advantage of. And a family may be evicted for drug-related criminal activity on or near the premises. So that's one area where they actually have an advantage over public housing residents. The drug-related criminal activity has to happen on or near the premises. We argue a lot about what near the premises means. Very often it's defined to mean the immediate vicinity. Sometimes it's defined to admit, the area that you can see when you're standing right outside the development. So we take a lot of those cases. The Housing Choice Voucher Program. This is fast becoming the federal government's primary vehicle for providing affordable housing to low-income families. It is administered by public housing authorities like the Chicago Housing Authority, the Housing Authority of Cook County. They draft administrative plans which govern their procedures for administering the program. The rental assistance in this tenant-based assistance program runs with the family as opposed to the unit. Okay, so here's how it works. Family gets what's called a voucher from the Public Housing Authority. And the voucher has a certain term. Okay, it might be 60 days, 90 days. And the family has to locate a suitable unit in the private housing market before the voucher expires. So they find a unit that they like, and they turn in what's called a request for tenancy approval, an RFTA, to the Public Housing Authority. The Public Housing Authority then inspects the unit to ensure that it complies with housing quality standards. They also negotiate a reasonable rent with the owner. And if everything passes, then there are going to be two contracts that you have to know about. The first contract is the lease agreement between the private owner of the assisted unit and the family. Okay? Only the owner may terminate the lease agreement. There's then a housing assistance payments, or HAP contract, between the owner of the assisted unit and the Public Housing Authority. Only the Public Housing Authority may terminate the family's assistance under the program. Okay? But there is a connection between termination of the lease agreement and termination of assistance. I'll get to that in just a bit. The Public Housing Authority calculates the family's share of the rent, and then it sends the owner monthly housing assistance payments, monthly subsidy payments that are equal to the difference between the total rent that the PHA has negotiated with the owner and the family's contribution as calculated by the Public Housing Authority. The Public Housing Authority can abate the owner's subsidy payments for failing to maintain the unit, and during the abatement process, the family remains responsible for its share of the rent, but the family is not responsible for the abated housing assistance payment. Very often you'll see a family that has a voucher is facing eviction for $1,200 rent, $2,400 rent. And typically what's happening in that case is that the PHA has abated the subsidy payments and the owner is going after the tenant for those subsidies, and that's not allowed. The family is not responsible for the abated subsidy payments unless the family caused the conditions problems that led to the abatement. If you want to find out who's responsible, you can get a copy of the inspection report, and it will attribute the fail items to the responsible party. Sometimes certain items are attributed to the family, other items are attributed to the owner. In almost all the cases that I've seen, the vast majority of problems are attributed to the owner. Now, this is a significant difference between the Housing Choice Voucher Program and other subsidy programs. The owner may terminate the lease agreement without good cause at the end of the initial lease term or any successive lease term. Okay? Now, why is that? In the other subsidized housing programs where the rental assistance runs with a unit, you can't terminate it without good cause because you're terminating, again, not just the tenancy, but the rental assistance. But that's not the case in the Housing Choice Voucher Program. If the landlord terminates the lease agreement, the family gets moving papers so it may relocate to another assisted unit. Okay? The owner may terminate the lease for good cause at any time. And this is an important provision. There is a federal regulation governing the Housing Choice Voucher Program that says the Public Housing Authority must terminate assistance if a family is evicted from an assisted unit for a serious lease violation, which could be something as relatively insignificant as non-payment of 1 month's reduced rent. That is why we take these eviction cases extremely seriously. When a family that has a voucher is facing eviction for cause, they will lose their assistance if they lose the eviction action, because the PHA is going to say this is a mandatory termination of assistance. We have no discretion in these cases. All right. If the family is facing eviction without good cause, we will sometimes take those cases, even though that type of eviction action is not going to jeopardize the family's assistance under the program. But the reason we'll take it is because it can take the family a long time to find another assisted unit to which it may relocate. And so that is the only time that we will get involved in a case just to buy the family or the tenant time to move. We are always accused of doing this, okay? Every time we step up in court, the landlord's attorney will say, they're just here to delay, and that is not true, except in this case, okay? We are almost always in the case to win it, because if we're representing a subsidized housing resident, again, it does them no good, it does us no good to just buy them a few more months. We've got to preserve their subsidized tenancy. When you've got a voucher holder who's facing eviction without good cause, we'll get involved just to buy them some time to make sure that they don't get evicted before they've been able to find another suitable unit and relocate to that unit. And it can take a good amount of time, not just because of the public housing authorities that can take some time to come out and inspect and to negotiate the reasonable rent, but because there's a lot of source of income discrimination that goes on in Cook County, even though in Cook County it is prohibited. Okay? Cook County and the city of Chicago both prohibit source of income discrimination, and Cook County is a little more specific about protecting voucher holders and saying that, yes, the rental assistance you receive under the voucher program is a source of income. The Chicago Fair Housing Ordinance is not as specific, but it has, thankfully, been interpreted by the appellate court to protect voucher holders. But even though that discrimination is prohibited, even though landlords are not allowed to refuse to rent an apartment to a voucher holder solely because they participate in the voucher program, there's a tremendous amount of discrimination that still goes on. Sometimes because owners don't know about the prohibition against source of income discrimination, and sometimes because they don't care. And it is shocking to see how many times owners will say, sometimes they will even put down in writing, that they will not take what they will call Section 8. The Housing Choice Voucher Program is sometimes called Section 8. That's a misnomer. It's really referred to as the Housing Choice Voucher Program. All right. This is the process that a public housing authority has to follow if they're going to terminate assistance under the program. The first thing the public housing authority has to do is issue written notice of its intent to terminate assistance. The ITT notice has to go out. The notice will set forth a deadline for requesting a grievance hearing. It's usually 30 days. If the family submits a timely request for a hearing, the Public Housing Authority may not terminate assistance unless and until the hearing officer upholds the initial decision to terminate assistance. All right, so it's very important to submit a timely request for a grievance hearing. That'll keep the assistance flowing pending the resolution of the hearing. It means that the landlord will continue getting the subsidy payments, and the landlord won't then file an eviction for non-payment of rent. If the family loses the administrative hearing, you can challenge the final administrative decision several ways. The most common way is by filing a petition for certiorari within 6 months. Okay, that can be filed in state court, it can be filed in federal court. Very often we file in state court. In some situations, you may want to file a Section 1983 challenge in state or federal court. I'm sorry, I just misspoke. The petition for certiorari would only be filed in state court. The Section 1983 challenge could be filed in state or federal court. A Section 1983 challenge is a little more difficult. You have to allege a due process violation or that there was a violation of a statutory provision governing the Housing Choice Voucher Program. The advantage to a Section 1983 challenge is that you've got a longer statute of limitations. It's 2 years. If you are challenging an administrative decision that upholds the initial determination to terminate assistance, at that point, the Public Housing Authority will stop sending subsidy payments to the landlord. So what you have to do when you file your judicial challenge is you also have to file an emergency motion for a temporary restraining order and a motion for preliminary injunction to keep the rental assistance flowing pending the resolution of the judicial challenge. All right, and we file those all the time, and we almost always win them. You do have to, of course, establish, as you would anytime you're seeking injunctive relief, that you have a likelihood of success in the merits, but we're probably not going to be taking a case unless we think that we do. So those are the three main subsidized housing programs that you're going to be hearing about. The public housing program, the Section 8 project-based programs, and there are about 8 different Section 8 project-based programs called new construction, moderate rehabilitation, substantial rehabilitation, and then the Housing Choice Voucher Program. But there are many other subsidized housing programs, federal, state, and local. Okay, some are designed, I state here, to assist a certain class of tenants. You've got HOPWA, the Housing Opportunities for Persons with AIDS. You've got Shelter Plus Care, which deals with people who are HIV positive or have AIDS or have other issues, sometimes addiction issues. You have the Veterans Affairs Supportive Housing, the VASH program, which is also a tenant-based assistance program. It's essentially the Housing Choice Voucher Program, but for veterans. All of these programs are governed by different sets of statutes, regulations, plans, and agreements. So it can get quite complicated and quite interesting taking on these cases. But if you're going to be referring a client over to us, if you can, it's helpful for us if we know what kind of subsidized housing program is involved. If you can't figure it out, we can do it pretty quickly. Any questions about subsidized housing? Oh, all right, yes?
So when you were talking about the criminal activity for drugs, what do you mean by activity? Is it like a charge? Is it a conviction? Is it
That's a great question. The federal regulations actually say there doesn't have to be a conviction. There doesn't even have to be an arrest, although you don't often see cases where there isn't an arrest because how else are they going to find out about it? But they could, and we have seen this, say I was walking by this person's apartment and I smelled marijuana. Okay, and so I'm going to evict them. There's no arrest, there's no conviction. The fact that there doesn't have to be a conviction can be confusing sometimes to our clients. And they'll come to us and they'll say, well, this shouldn't be a problem because, you know, my son, he was arrested, he went to court, the criminal charges were dismissed, so the case should be all over. And you have to take time to explain to them that's not the case, okay? And it's because of the different standards of proof in criminal courts and in civil courts, and eviction cases are heard in civil courts. So what we try to explain to our clients is that just because the state cannot prove beyond a reasonable doubt that a crime happened, that doesn't mean that CHA should be precluded from trying to establish by a preponderance of evidence in civil court that the crime happened. And if they can meet that standard, then they can win the eviction action. And the easiest way I've found to explain it to clients is by mentioning the O.J. Simpson case, which everybody's familiar with. And we say, look, remember O.J. was in criminal court and he was acquitted, but then Ronald Goldman's family brought a wrongful death action against him in civil court, and he lost that case. Okay, and the reason they were able to proceed with a wrongful death action in civil court is because of the different burdens of proof. Okay, so does that answer your question? Okay.
But the
yes.
arrest alone is not enough.
I'm sorry?
The arrest alone, so if they arrest somebody,
That's
the
correct.
arrest alone is not enough.
That's not evidence, right? You need some corroborating evidence. Some testimony if you don't have a conviction. Not to get too deep into the weeds, but there are cases in which we are representing tenants who are arrested for a very insignificant crime, like possession of a single joint, and they go to court, they get a public defender, they don't have a criminal record, and so the state offers a plea. They say, look, plead guilty, and we'll give you a sentence that involves no incarceration, supervision, or probation. And the public defender will then pressure the tenant to take the plea, because they'll say, why wouldn't you? Why would you risk, going to court? You're not going to have to spend a day in jail, so just plead guilty and you'll be fine. And very often the public defenders don't understand what we call the collateral civil consequences of a guilty plea. What happens when the tenant pleads guilty is that that's then a conviction, okay? And every year in the subsidized housing programs, the public housing authorities, the owner of the Section 8 developments, are going to be recertifying the family, and they're going to run a criminal background check on all the adult household members. And if they pull up a conviction, then they're going to file an eviction action. And then the problem is that the conviction is going to come in to the eviction case, and it's going to essentially resolve the issue of liability. We have been able to argue that under certain circumstances, a tenant who pled guilty in a criminal proceeding should be allowed to maintain his or her innocence in a subsequent civil proceeding, if you can establish that they're actually innocent. Well, that's what you're trying to get an opportunity to do. You have to show that the tenant had no incentive to litigate the innocence defense in the criminal proceeding. And the way that you show that is by saying, look, they were offered a sentence that involved no incarceration, so why would they have risked going to trial to litigate the innocence defense? You also have to establish that the tenant did not know how the conviction could jeopardize his or her subsidized tenancy. That's getting a little harder to do now because of a new provision of the Criminal Code of Civil Procedure, which went into effect just this year, January 1st of this year. Judges now are required, before accepting a plea, to make sure the tenants understand the civil collateral consequences of the plea. Now, I don't know how this is all playing out. I haven't been to criminal court and heard what a judge actually says. But specifically, the judge is supposed to tell them about how it could affect their housing. Now, my guess is that judges are running through this very, very quickly, and that criminal defendants are not really understanding what the judge is saying. But it could make it more difficult for us to argue that the tenant did not understand when they entered the plea what the potential consequences could be on their housing. Any other questions?
Have we talked to the public defender's office about this issue?
Yes.
Profile?
Yeah. We train public defenders every year on the civil collateral consequences, and so this issue is coming up now. The last time we had the training, nobody had really seen it go into effect, and so we haven't had that discussion yet, but it will become part of our discussion. All right, eviction defense. Why is it so important? The answer is in Matthew Desmond's Pulitzer Prize-winning Evicted, Poverty and Profit in the American City. This is one of the best books I've ever read. Everybody should run out and get a copy of it right now. It's the best thing I've ever read on what evictions actually mean, what the effects of evictions actually are. I think it's very balanced. It also, I think, is very sympathetic to landlords who are trying to evict bad tenants. But his thesis, Matthew Desmond's real thesis in the book, is that evictions are not just a symptom of poverty, they're actually a direct cause. And he concludes that evictions constitute, quote, one of the most urgent and pressing issues facing America today. And that's certainly true here in Cook County, where more than 40,000 eviction actions are filed every year. And most of these eviction actions are filed against low-income families, many of whom have young children or household members who have a disability. And many of them have subsidized tenancies. I don't know what happened to that slide. I tried to actually correct that. Okay. First thing you have to know about the eviction process, lockouts are strictly prohibited. If a landlord wants to evict a tenant, they can't just decide to change the locks on the door. They have to follow the legal procedure. So this is the legal procedure. The landlord has to first file suit. The landlord has to win the eviction case and obtain a judgment for possession, which is we're soon going to be calling on January 1st, 2018, an eviction order. And then the landlord has to pay the sheriff to enforce the judgment by going out, and in Cook County what the sheriff does is the sheriff just changes the locks on the doors. It used to be, when I started, that landlords would come into a unit and throw all the belongings into the street. And in most of the neighborhoods where our clients live, the belongings would be there for no more than an hour. So the situation is a little bit better now. What's unclear is how long the landlord has to keep the possessions. I've seen no case law on this, and it's a very hazy procedure, but it seems that most tenants who face this situation are able to negotiate with a landlord to come in and remove their belongings. Before filing suit, in most cases, the landlord is going to have to first terminate the tenancy with advance written notice, with a written termination notice. This is certainly true in all of the subsidized housing programs. The type of notice required depends on the reason for the eviction and the type of tenancy involved. A notice that's demanding the rent due must give the tenant time to pay. There's a state statute that says tenants have to have no less than 5 days to pay the amount demanded or the amount that's actually owed. Public housing residents are given 14 days to pay the amount due or to request a grievance hearing. If the tenancy is governed by a local ordinance, like one we have here in Chicago, the Residential Landlord-Tenant Ordinance, the notice must advise the tenant of his or her right to cure the violation, this would be other than a non-payment of rent case, within 10 days. Okay? And that's an extremely helpful right that a lot of tenants in Illinois cannot take advantage of. But in Chicago, in Evanston, tenants do have a right to cure. We often argue with landlords about which violations can and cannot be cured and what an effective cure actually means or what constitutes an effective cure. But the right to cure is very important, and the termination notice has to advise tenants of their right to cure if they have that right. In some circumstances, the landlord may be able to terminate the tenancy without good cause upon 30 days advance written notice. That would be in a month-to-month situation, or when you're dealing with a voucher holder, remember the tenancy can be terminated upon 30 days advance written notice either at the end of the initial lease term or at the end of any successive definite term. So after the termination notice expires, the landlord can file the eviction action and they can seek possession of the premises. They can also seek the rent due. Eviction actions are what are called summary proceedings. They're supposed to move along very quickly. Nevertheless, parties are entitled to discovery and also a trial by jury. Most of the times when we're filing our appearance, we will submit a jury demand. A landlord who prevails at trial obtains the judgment for possession, again, it's soon going to be called an eviction order, and the rent due plus costs, and if it's not prohibited by a local ordinance, attorney's fees. The local ordinance that we have here in Chicago, the Residential Landlord-Tenant Ordinance, does preclude landlords from getting their attorney's fees in an eviction action. Okay. However, in a case that we were involved in, made it clear that if the defendant in an eviction action asserts a counterclaim that is based on a violation of the Residential Landlord-Tenant Ordinance, and they prevail on that counterclaim, they are entitled to attorney's fees. And that was a big fight for a while. If the landlord gets an eviction order, a judgment for possession, the court will likely stay enforcement of the judgment for 7 to 14 days What that means is that during that stay period, the landlord cannot pay the sheriff to enforce the judgment. Once the stay expires, they can go and they can pay the sheriff, and then it typically takes the sheriff 2 to 3 weeks to get out to enforce the judgment. Only the sheriff may enforce judgments for possession. There's actually a case out of Illinois involving a mobile home resident who made it all the way up to the U.S. Supreme Court on that issue. Now, very often, someone will come to us, excuse me, I'm just going to check time. They'll come to us because they missed court and a judgment was entered against them. So we're very often vacating default judgments. Very often, it's very easy, rather, to vacate a default judgment within 30 days after the judgment's entry. When more than 30 days have passed, you can petition the court to vacate the default judgment, but you have to establish due diligence, explain why you're coming in more than 30 days after the judgment was entered, and you also have to set forth a meritorious defense to the eviction action. Also, it's the best practice. You don't really have to worry about this if you're not in the housing practice group, but I wanted to put it here anyway. You should always file what's called an emergency application for a certificate that there is probable cause to stay further proceedings when you bring your motion to vacate the judgment, okay? Because you don't want the sheriff coming out to enforce the judgment before you've had a chance to appear before the court for a hearing on your motion. Vacating agreed orders. This was a case where we had a significant victory a couple of years ago. And it also is one of the reasons that now the Illinois Supreme Court is trying to create plain language forms for the eviction courts. Many eviction actions are resolved through the entry of an agreed order that awards the landlord possession of the premises. But a tenant who signs such an agreement while unrepresented may be able to vacate the order if the evidence establishes that the order did not reflect the tenant's reasonable understanding of the agreement. Typically, it's very, very hard to vacate an agreed order. You can only do it if you can show fraud or duress or coercion. But we had a case on behalf of a client named Nicole King, and I think it bears a little bit of discussion. Ms. King lived in a Section 8 project-based development, and she had 2 young children, ages 1 and 2. And she paid a reduced rent equal to a percentage of her income, and then she lost her TANF, her cash assistance from public aid, and she delivered, or she put in the mailbox for the landlord proof that she was losing this cash assistance, and once they received that proof, they should have reduced her rent down to 0. But they said they never got it, and then she didn't pay the next month's rent, and so they served her with a termination notice demanding less than $200 in rent. Okay? And she went to talk to the property manager and said, look, you should have reduced my rent to 0. I lost my income. They said, we never got, proof that you lost your income. So they were arguing back and forth about that. And finally, the property manager said, look, we don't really want to evict you. So just agree to pay this amount of rent. We'll reduce your rent to 0 now, prospectively. But agree to pay the disputed amount of rent and also our fees, and we'll let you stay. And she thought, okay. So she gets the summons to appear in court, and she doesn't think she needs an attorney because she has this agreement. So she goes to court and meets the landlord's attorney out in the hallway and says, look, I've got an agreement. And the attorney says, yeah, I talked to the property manager. I can give you 15 days. And what the landlord's attorney meant is, I can give you 15 days to move, okay? I can agree to get an eviction order today, stay enforcement of it 15 days, and then you move out. And what Ms. King heard was, I have 15 days to pay the disputed amount of rent and your fees. And so she says to the attorney, 15 days is not enough, I'm going to need 30 days. And the attorney thinks, fine, I'll give you 30 days. And then says, sign this order. And this is the judgment for possession that I was talking about before. That's just full of legal terminology that nobody would understand. And she signs it in 2 places. And what this judgment says is that the landlord's getting a judgment for possession of the unit, plus the disputed amount of rent, plus court costs, and enforcement of the judgment is going to be stayed 30 days. So then she goes up to the judge, and the judge looks at the order, and the judge doesn't explain the order to her. The judge just says, "Is this your order?" And she says, "Yes," because it is. And he says, "Are these your signatures?" And she says, "Yes," because they are. And so he says, "Fine, I'm entering the order." And she leaves. And then about 2 weeks later, she gets the dispute. Oh, she also says to the judge, "What are the fees that I have to pay?" And he says, "You don't have to pay fees. You do have to pay costs, and it's this much money." It was about $300. So 2 weeks later, she gets the money together, $500 or so, and she brings it to her property manager. And her property manager says, "Look, keep your money. You're going to need it because we have an eviction judgment against you, and we're going to enforce it." And that's the first time that she learns that she's going to be evicted. Okay, so then she comes to our office and she says, "I need to vacate this agreed order." So we go in a motion to vacate, and we essentially argue that there was no meeting of the minds, that this agreed order cannot be enforced because it's not a valid contract. And we have a hearing, and there's testimony, and there's some irrelevant evidence that comes in because the property manager testified that, well, I should say, in response to questions from the judge, actually, who wanted to know why they were so intent on evicting this tenant. They said, well, she plays loud music at night, and also her cousin got involved in a fight near the premises, and we barred him from the premises, and she let him back in. This is all irrelevant. None of this was set forth in the termination notice. And so our attorney was objecting up and down, but the judge said, no, eviction actions are small claims proceedings, and the rules of evidence don't apply in small claims proceedings, so I'm going to let all this evidence in. And then at the end of the hearing, the judge says something very interesting, and thank God Lizzie Rosenthal, who I mentioned before, had thought to bring a court reporter to the hearing. And the judge says this on the record. The judge says, the vast majority of eviction cases are resolved through the entry of an agreed order, and that's true. And then he said, in the vast majority of those cases, the landlord is represented by an attorney and the tenant is unrepresented, and that's also true. And then he said, in many of those cases, the tenant does not understand the terms of the order they're signing. And then he said, I still enforce those orders, which was really shocking. So we took that case up on appeal, and we got a published decision that you can cite, not just a Rule 23 order. And the court reversed, as an abuse of discretion, the trial judge's refusal to grant our motion to vacate the agreed order. And I think that was when it became apparent to a lot of people how significant this problem was, how pervasive and significant it was. So it is easier to vacate agreed orders in these situations now. Hopefully we won't have to do that once we get more plain language forms in the courtrooms. Sealing an eviction record. Some of your clients may ask about this. It's not enough to win an eviction action, because once an eviction action is filed, there's a record of that. And landlords can check that record. So anytime a landlord has a prospective tenant, first thing they do is they click onto the clerk of the circuit court's website, they enter the defendant's name. It's very easy to do this, to see if the defendant has ever been, or see if the prospective tenant has ever been the defendant in an eviction action. And if they have, that's usually all the landlord needs to know. And the landlord is not going to care whether the tenant won that case, because the landlord's going to say, well, I know that I don't file an eviction action unless I really need to, and so I'm going to assume this landlord had a good reason for filing, and this is not a tenant I want to take a chance on. This becomes a huge problem when you're talking about voucher holders, who, remember, can be evicted without good cause. Okay, so they've done nothing wrong, but they weren't able to get out of the unit before the 30-day termination notice expired, so an eviction action gets filed against them. And then their search for new housing becomes much harder because the prospective landlords keep checking the website to see if they've been the defendant in an eviction action, and of course they have. So it's very, very important to seal records when you can. Sealing the court file is mandatory when the eviction arises from a foreclosure, so that's easy, okay? But in all other cases, sealing the eviction record is discretionary. And here's the standard. You have to show that the plaintiff's action is sufficiently without basis in law or fact. You have to show that the tenant has a compelling interest in sealing the record, and you have to show that this interest outweighs the public's interest in accessing court files. It's pretty easy to show that tenants have a compelling interest in sealing the records for the reasons I just gave, and that this interest outweighs the public's interest in accessing court files. It can be very difficult to show that the plaintiff's action is sufficiently without basis in law or fact, because what does that mean? Is that tantamount to the standard that's set forth in Supreme Court Rule 137, where you're saying if somebody files a case that's not sufficiently, or does not have a sufficient basis in law or fact, they can be sanctioned? Or does it mean that after discovery was complete, after the tenant filed an affirmative defense, the tenant was able to establish that they would prevail on that affirmative defense? I think that's what it should mean, the latter. But it can be hard, and a lot of judges do not like to seal records. Furthermore, the parties' agreement to seal may not be sufficient to get the court file sealed. With some judges it will be, other judges it won't be. I attended a training that all the other eviction court judges attended, and it was given by a judge who does not sit in eviction court. And he hates the idea of sealing. And he was citing all these other cases that talk about why you shouldn't seal the record, and he didn't understand how these cases should be distinguished from eviction cases, and why the interest in sealing is so strong in the eviction context, and why the public's interest in accessing the court files is not that strong. And you'll often see, if you read these cases, they talk about the fact that you should never seal just because a litigant would be embarrassed if people had access to the record. Well, that's not why tenants want to seal these records. They're not trying to avoid embarrassment. They're trying to make sure that they can get rental housing. All right, any questions on anything I've mentioned so far before I go into silo busting between the practice groups? Okay, yes?
Quick question, the grievance procedure process, how long does that take in Chicago with CHA?
With CHA, when they get a termination notice and then request a grievance hearing, the grievance hearing will usually be scheduled pretty quickly, a week or two out, usually. And then if they lose that informal hearing, which is really just a meeting in the property manager's office, then they can request a formal administrative hearing, and that'll probably get scheduled about a month out. Okay, and then if they lose that formal hearing, okay, only at that point can the Public Housing Authority consider their lease terminated and then file an eviction action. So when somebody submits a timely request for a grievance hearing, they get 3 bites at the apple: the informal hearing, the meeting, the formal administrative hearing, and then the eviction action. Okay, in the voucher context, when you request a hearing, that can take a lot longer. Sometimes it takes them months to schedule a hearing, and we don't really care in most cases because the assistance is still flowing during that process, as long as the request has been submitted in a timely manner. Anything else? Yes, John.
Have you ever tried asking the court if we could take the hearings?
I'm sorry, take which hearings?
Any hearing where there's not a court reporter.
Well, in eviction court, you can bring a court reporter.
Right, no, we can't afford one, so my question is, could you just ask the judge, I'm just going to take the hearing? You answered my question, it sounds like you've never asked.
I'm not aware of it. Jessica, did you ever hear of that being done? No? Mm-mm. I haven't, but it's interesting.
Don't they not allow you to have your phones or your
Yeah, you can have the phone, you just have to turn it off. So I guess you could ask the judge for the right to turn it back on and record. I don't know, it's interesting.
So I thought just going to the presiding judge and say, Judge, we can't afford a court reporter. Would you mind if we just got a standing order to take?
Yeah.
As long as we notify everybody, because then that's all that's required.
Yeah, that could be a very good idea. We do, as part of our initiative to improve the administration of justice in the eviction courtrooms, we do meet with Judge Wright on a regular basis, and so it's something we could raise with him.
And then if you publicize and allow clients to do that on their own, because so many people have phones now, they can record it.
Yeah, that's true.
As long as they let people know, because we're technically a two-party consent state. So.
Yeah. So, Well, it's interesting. We'll see what happens. There's supposed to be some movement on the initiative to get electronic recording devices, but if that fails, then we'll try that. Okay, silo busting with the Children and Family Practice Group. This is probably the group that we collaborate with the most. This is Rich Cazzola's group. So we are often representing tenants who are survivors of domestic violence, dating violence, sexual assault, or stalking. And there's a great law now, the Violence Against Women Act, and there are amendments on it that we rely upon that protect residents of all federally subsidized housing. It didn't used to be that comprehensive, but it is now. It covers every federally subsidized housing program, and this is what it states. I'm just going to quote from it. It protects an applicant for assistance under a covered housing program or a tenant assisted under a covered housing program, says they may not be denied admission to, denied assistance under, terminated from participation in, or evicted because of her status as a survivor of domestic violence, dating violence, sexual assault, or stalking. Okay, and that's very helpful. I'll just give you one example. I was representing a woman who lived in a Section 8 project-based development, and one night her fiance came over and he just beat the hell out of her, and then he left. And she calls her property manager, and the property manager calls the police, and the property manager and the police come to her unit, and they knock on her door, and she answers the door, and it's obvious that she had been beaten. In fact, the termination notice that she received the next day actually stated that. It was obvious that you had been beaten. Your face was covered with scratches and what appeared to be bite marks. Okay? And then they said that she was going to be evicted pursuant to the lease provision that holds her responsible for the violent criminal activity of her guests. And the landlord was saying, well, look, your fiance was your guest. You let him into your unit. He then committed this crime. And so you are, under the lease, responsible for that crime, and we're going to evict you. And it was really outrageous. And she went to get an order of protection from Dave Harris, the judge that I mentioned, who's a former LAF attorney and now a domestic relations judge. And he sent her to us. And we represented her, and VAWA did not exist at the time. And so our argument was, look, this guy stopped being her guest the minute he started beating her up. And also, you just can't evict the victim of a crime for the fact that that crime happened. And then while I was, it was my case, and while I was representing her, I read in the Schreiber Center's clearinghouse about these two cases that had brought claims under the Fair Housing Act. And in similar cases, and they accused the landlord of violating the Fair Housing Act. They've accused them of sex discrimination, gender discrimination. And the theory was this, that statistics show that 98.5% of the victims of domestic violence are women. So if you have a policy of evicting victims of domestic violence for acts of domestic violence, that has a disproportionate impact on women and violates the Fair Housing Act. And I remember, reading about this theory and thinking, well, that's really clever, but I don't buy that. And then I read that I was completely wrong, and that in both cases that had been brought in federal court, the tenants had survived motions to dismiss, and the cases then settled. So then I very quickly drafted, affirmative defenses and counterclaims under the Fair Housing Act, and the case was dismissed. But now that we have VAWA, you don't have to go through all of that, at least when you're representing a federally subsidized housing resident. We also have, here in Illinois, the Safe Homes Act. So this covers unassisted rental housing, which VAWA doesn't. Also housing assisted under the Housing Choice Voucher Program, Section 8 project-based developments. It does not cover public housing. And this act says that a survivor of domestic or sexual violence may break the lease and vacate the premises without incurring responsibility for rent that accrues during the rest of the lease term. And in emergency situations, survivors can also change the locks to keep the abuser out of the unit, as long as they provide the landlord with a copy of the key. And then we have the Eviction Act, which is still known right now as the Forcible Entry and Detainer Act. And because it's called that, a lot of people don't know what it has to do with evictions, but it covers the eviction process. Again, January 1st of 2018, it will be called the Eviction Act. This governs all dwelling units, and it provides that A tenant who's facing eviction may assert as an affirmative defense that the landlord's demand for possession is based solely on the tenant's status as a survivor of domestic violence, dating violence, sexual assault, or stalking. So we do have other laws that we can rely on. A couple other state statutes just to know about quickly. There's one that provides for a deferral for 60 days of the utility's initial credit and deposit requirements for a residential customer or applicant who's a victim of domestic violence. And there's another prohibition against ordinances that penalize tenants for contacting the police or other emergency services. Because there are these nuisance ordinances that you'll read about that say, look, we can evict you if you're calling the police too often. But if you're getting beaten up a lot, then you've got to call. So there is a state statute now protecting those tenants. Any questions about collaborating with the Children and Family Practice Group? Yeah.
What kind of documentation is typically required? Like, I know under state homes they want a plenary. Is there anything else that works for that, or is it just a plenary?
Yeah, usually, I mean, I can send you another. Nehal Lal just did a presentation on this. But very often what you can get is you can get information from the police, God bless you. You can get information from a social worker who has worked with the victim, somebody from a shelter, okay, just documenting the fact that this person actually is a survivor.
Oh wow, and that's usually enough to change locks and stuff?
It usually is. I can send you, or I can send all of you actually, when you sign up, if you have your emails, a list that shows you exactly what documentation is required in different situations. Okay. All right, silo busting with the Consumer Practice Group. Again, let me just check the time. Okay. We will often, as I alluded to before, use the bankruptcy code to help preserve someone's tenancy when they're facing eviction for non-payment of rent. So a tenant who's facing eviction for non-payment of rent, owes the rent, can't pay the amount due before the termination expires, can file for bankruptcy protection and assume an unexpired lease. Okay? As I mentioned before, the lease expires when it terminates, so you want to file your voluntary petition for bankruptcy before the termination notice expires, or in the public housing context, before the grievance process ends, provided the public housing resident has submitted a timely request for a grievance hearing. You can file after the notice expires and before judgment has been entered, but it's risky, and filing post-judgment is pointless. Okay, the lease is absolutely expired by that point. If you're going to file in that second stage, after the termination notice is expired, but before a judgment has been entered, you're really at the mercy of the bankruptcy judge. Because what happens when a bankruptcy petition is filed is that an automatic stay will bar commencement or the commencement of or continuation of a pending eviction action. But then the landlord can file a motion to modify the automatic stay and argue that the lease is expired or that the tenant's Chapter 13 plan does not adequately protect the landlord's economic interests. If you file before the termination notice expires, while the lease is clearly still in effect and clearly unexpired, almost every motion to modify will be denied. But if you're filing in that second stage, it might be granted. And again, I've had bankruptcy judges go both ways. If they do modify the automatic stay, what that means is they just allow the eviction proceeding to continue. And if you have other defenses, then great, you can try to prevail on them. But most of the time, if you're filing Chapter 13, it's a last resort. Chapter 13 plans are usually not feasible. Well, they're just not feasible unless the tenant has a regular source of income and can pay all the rent owed over a period of 3 to 5 years. So when you're filing the bankruptcy petition, you identify the landlord as a creditor. You have to, in your plan, say that over the next 3 to 5 years, I will pay the landlord everything I owe. You can pay other creditors just a percentage of what you owe, but you've got to make the landlord whole, at least here in the Seventh Circuit. So using Chapter 13 to help a public housing resident, I've talked about this already. Just make sure that you keep the lease in effect by submitting a timely request for a grievance hearing, and if you lose the initial hearing, submit a timely request for the formal administrative hearing. Now, Chapter 13 of the Bankruptcy Code is used when you're saying, I want to reorganize my debts and I want to pay back my creditors everything I owe or a percentage of what I owe or a period of time. Chapter 7 is different. Chapter 7 is what you file when you say, I just want to wipe out the debt. Okay? I'm not going to be paying anybody anything. Okay? A Chapter 7 debtor may not assume the lease. All right? So it's not what you want to file on behalf of a tenant who owes the landlord rent and would have to identify the landlord as a creditor. But Chapter 7 can still be useful in other situations, and I want to go over those right now. In the voucher context, the tenant's going to be far less concerned about preserving the lease agreement with the private owner, and they're going to be more concerned about preserving assistance under the program. So a voucher holder who's facing eviction for non-payment of rent can wipe out the debt to the private owner of the assisted unit and still preserve her rental assistance under the program, because there is what's called an anti-discrimination provision in the Bankruptcy Code that prohibits public housing authorities from using the bankruptcy filing as grounds for terminating the debtor's rental assistance, okay? Because the debtor has wiped out a debt not to the public housing authority, that you don't want to do that, but has wiped it out to a third party, to the owner of the assisted unit, and then that cannot be held against them by the public housing authority. You can also use a Chapter 7 bankruptcy petition to help a subsidized housing resident who's facing eviction for failing to maintain utility services. In lease agreements, even in the subsidized housing context, tenants are often responsible for maintaining their own electric service or gas service. And if a tenant has failed to do this and then gets a termination notice that affords them the right to cure the violation, which they will in Chicago, you can use Chapter 7 to eliminate the debt to the utility company before the termination notice expires. You've got to make sure that your client is current in rent so you don't have to identify the landlord as a creditor and risk the tenancy. And just to give you one example of how this was done many years ago, I had a tenant on the west side who was a public housing resident, and the gas company had actually come into her unit, okay, and removed her gas meter from her closet, okay, because she had a $10,000 bill. And typically, gas companies will not allow the bill to get that high. They'll just shut you off from the street. But her meter was in her closet, so it just got to this point where she had a $10,000 debt, and then People's Gas went in to get a replevin order, and they got the right to enter her unit and remove the meter. And so then CHA turns around and gives her a 10-day notice saying, you didn't maintain your utility service, we're going to terminate your tenancy. So she was current in her rent. So I filed a Chapter 7 bankruptcy petition and notified People's Gas, and then you have to pay a security deposit, which is not that much. And they had wiped out her debt, but they had to bring back the meter, and they restored it in her closet. And this was all done before the termination notice expired. So then we argued that she had cured the lease violation, and CHA agreed, and they did not pursue an eviction action against her. I have to say, I talked about this case. I teach a class on poverty and housing law at the University of Chicago Law School, and I talked about this case when discussing the Bankruptcy Code, and it was the first year, it was 17 years ago, it was the first year I was teaching the class, and I thought the students were all going to stand up and applaud. And there's just this deathly silence. And then one student said, "That's bullshit," which is, I always think about the University of Chicago's law and economics philosophy. But they weren't as thrilled. They think it's fine if a corporation can do something like this, but not if an individual can. I hope they came around by the end of the class. All right, as far as collaborating more with the Consumer Practice Group, you can sue for violations of the Fair Debt Collection Practices Act's venue provisions. The venue provisions of the FDCPA provide that a debt collector, must file suit in the municipal district where the debtor either signed a contract or currently lives, and rent is a debt to which the FDCPA applies. So an attorney who files forcible actions may be a debt collector within the meaning of the FDCPA. It depends how often the attorney files debt collection actions. And so an attorney may violate the FDCPA's venue provision by filing a joint forcible, or soon it'll be called eviction actions, thank God. That's one that seeks rent in addition to possession. If they and they violate the FDCPA venue provision if they file in the wrong municipal district, and they often do. And the reason landlords do is because there are 6 municipal districts in Cook County, and landlords like to file where they know the judge, and there are some judges that are much more favorable to landlords than to tenants. Or some landlords like to file in a district that's far away from where the tenant lives, that might be convenient to the attorney but not to the tenant. And they know that if the tenant can't get out there, they can get a default judgment against them. An attorney who violates the FDCPA's venue provisions is liable for $1,000 plus attorney's fees. When it was a Seventh Circuit case called Suez that came down interpreting the FDCPA's venue provision this way. And when that decision came out, there were just a ton of cases filed against landlords' attorneys. There's just a year-long statute of limitations on these violations, so most landlords' attorneys cleaned up their act, and you don't see too many of them making a mistake that would subject them to suit. Finally, you can sue for violations of the Credit Reporting Act. We often collaborate with the Consumer Practice Group on behalf of tenants who live in foreclosed buildings, because it's the Consumer Practice Group that represents owners of foreclosed buildings, but very often they are tenants who are living in these foreclosed buildings and don't know that the building has been foreclosed upon until they get a termination notice, or sometimes until the sheriff comes out to the building. All right, silo busting with the Public Benefits Group. We are often representing tenants with disabilities, and of course the Public Benefits Group is also representing clients with disabilities. Very often, a tenant with disabilities is facing eviction for a lease violation that is directly related to the tenant's disability. And in those situations, you may be able to assert what's called a reasonable accommodation defense. Okay? And what you're saying is, and you would bring this action under the Fair Housing Act. You would say, okay, our client has a disability. The violation for which they're facing eviction is directly related to that disability. We are requesting this accommodation that will allow our client to preserve her tenancy. Now, the accommodation has to be reasonable. It can't impose undue financial or administrative burdens on the landlord. And just to give you some examples of when you might want to do this. The first time I raised the reasonable accommodation defense, it was on behalf of a woman who was a public housing resident. She lived in a scattered site development. She had a townhouse. She had both floors. She had 5 children, the oldest of whom was 18. She worked as a secretary. Her rent was about $100 a month. And one day, her 18-year-old son got murdered on her doorstep, and she was the one who found his body. And she just fell into, as you would, this debilitating depression, and she stopped going to work, lost her income. But she wasn't taking care of her business, and she didn't notify her landlord that she wasn't working anymore, so her rent was still $100. And she didn't pay for 3 months. During that 3-month period, she tried to commit suicide by taking a bottle of pills, but she didn't want her children to discover her body, so she made herself throw up the pills, and then an ambulance came, they took her, she was in a psychiatric ward, and then she got under a psychiatrist's care. Again, this whole time the rent is accruing. Finally, after 3 months, CHA serves her with a termination notice demanding the $300 in rent. And she ignores it, and then they serve her with summons to appear. They file suit, serve her with a summons to appear in court, and then she comes to us. And I thought, well, this will be an easy case to resolve. I'll just call up the property manager, I'll call up the lawyer rather, and explain the situation. And they said no, they were going to go ahead with this. And so we asserted a reasonable accommodation defense, saying, look, the only reason she didn't pay rent is because of this disability. By this time she was under psychiatrist's care, who had diagnosed her as suffering from post-traumatic stress disorder and generalized anxiety disorder. And we're saying, but for this disability, she would not have fallen behind in rent. and here's the accommodation we're asking for. We're just asking you to not wipe out her debt, but just give her a second chance to pay the $300 that she owes. She's now under psychiatrist care. She's getting disability benefits. She can, from this point on, comply with her obligations as a tenant. And CHA said no. And denying a request for a reasonable accommodation, provided the request is actually reasonable, constitutes discrimination under the Fair Housing Act. And so we had an affirmative defense, and we also had a counterclaim. That case actually went to a jury trial. There were dispositive motions filed by both sides, and the court said, no, we've got to let a jury decide whether your accommodation request was reasonable. And the jury found that it was. So that's just one example of what we can do on behalf of tenants with disabilities. We also are very interested in medical legal partnerships, and Elise Citrini, who's here, runs LAF's medical legal partnership program. There's obviously a strong connection between housing conditions and health, and the common conditions or conditions problems that affect health. Some of them are listed here: mold, inadequate heat, poorly insulated units, lead paint, it's a huge one in Cook County, plumbing issues, bed bugs, vermin. And so Elise sometimes will refer her clients to us because they're tenants who are living in substandard housing, and that substandard housing is creating the medical issue. And so very often doctors can identify these issues, and as doctors become more familiar with the way that conditions can affect health, they're interested in referring them to Elise, who can then refer them to us so that we can try to improve the conditions. Silo busting with immigrants and workers' rights. We've got just 8 more minutes, and we don't have far to go. All right, in the subsidized housing context, most times someone who's eligible for subsidized housing has to be a United States citizen. However, there is a definition in the regulations governing the public housing and Section 8 programs that identifies mixed families as families whose members include those with citizenship or eligible immigration status and those without. And they may be eligible for continued assistance, temporary deferral of termination of assistance, or prorated assistance. So if you see someone who thinks they're not eligible for subsidized housing because they're not a citizen, if they are part of a mixed family, refer them to us. I have to say, I've been doing this for 27 years. I've never seen one of these cases, but I'd be interested in seeing one of them. Obviously, we're interested in housing discrimination cases, and we've had several of those in which tenants are facing eviction because of national origin, ancestry. And finally, Nubia Willman just brought this up to me. We can sometimes help undocumented tenants whom we can represent if they're victims of violent crimes, obtain U visas. And we would do this work with Matt Lango. He's a former LAF attorney, now at the Chicago Commission on Human Relations. So again, I haven't seen one of these cases before, but it could be a situation in which you've got an undocumented tenant, they are a victim of a crime, they might be eligible to obtain a U visa and become documented and stay in the country. So that is the last silo busting slide that I have, and we now have 7 minutes for questions if anybody has any questions. Yeah?
People who live in, this might be the wrong vocabulary, but affordable housing developments, like places where it's like a low-income housing tax credit, does that count as subsidized, and do they have the same protections?
No, they very often don't have the same protections. It depends, and that's why I say all of these different programs are governed by different sets of federal, state, local regulations. You have to see, but that's an important distinction because typically when we're talking about subsidized housing, we are talking about housing where the rent is equal to a percentage of the household income. But there then is, as you say, affordable housing where the rent is set at a certain rate and it's affordable, but it doesn't change. Okay, so if the tenant all of a sudden loses all their income, they may have to move out of affordable housing because they just can't afford even the lower rent. Okay, but we are very interested in those cases, but it is an important distinction.
So for LAF priorities, that skews on the side of subsidized versus not?
Yes,
okay.
Yes, we have a lot of affordable housing cases. Anything else? John?
Larry, how much how much are landlords sensitive to being shamed by adverse media?
It's a great question. They're very sensitive to it, and you have to be careful about when you threaten it, because you don't want to make an idle threat. But we have used this very effectively in the past, and landlords can't stand it. I had a case where CHA was evicting an elderly woman for a very small amount of rent, if I can even remember the facts of this case. And we did go to the media on it, and and the CHA representative was so mortified when he was called by the reporter that he said, CHA doesn't evict seniors for non-payment of rent, which was not true at all. And that's not their policy, and that shouldn't be their policy. But it gave you a sense of just how terrified they are of bad publicity. So they really are. I think that they were terrified of the bad publicity that came up when they threatened to take out of their lease the provision that afforded tenants to raise new or should have known defense. The public hearing was covered by both the Tribune and the Sun-Times, and the coverage was very favorable. And then there were editorials that supported our position, and they backed off because of that. So the media is an incredibly effective tool, but use it sparingly and only in the best cases. Nehal Lal and Tanerica Brooks and Kate Walls from the Shriver Center were collaborating on a case on behalf of a woman named Mary Blakemore. You may have been reading, this case has gotten a lot of publicity in the last year. It was a woman who was burned out of her unit. She lived alone in a public housing unit, was owned by the Housing Authority of Cook County. And the police brought her daughter and two of her grandchildren to her unit because they were trying to protect her from the daughter's abusive ex-boyfriend. And she said, sure, they can stay with me. And so they dropped them off. And then the boyfriend showed up. And Mary Blakemore called the police, and he left before the police arrived. But then when the police left, he returned, and he had a can of gasoline, and he poured it through an open window and set it on fire and burned the unit, and it sent Mary Blakemore and her grandson to the hospital with very serious burns. And they were there for a couple months. And then when they got out, the Housing Authority of Cook County, refused to rehouse them, which we considered to be a lockout. And their reason for refusing to rehouse her was that she was essentially responsible for the fire because she had allowed her daughter to come into the unit, and the daughter was like a magnet for the abusive ex-boyfriend, who, by the way, is in prison now for, I think, 47 years for attempted murder, for arson and attempted murder. And they also said, we're not going to let her back in because she owes us $168 on a repayment agreement. And there was that amount of money left on the repayment agreement, but she was current in the repayment agreement at the time the fire happened. And this was just outrageous. And so we went to the media on that case. And the media were outraged by it as well. And so there were editorials that were issued, and it led to a very favorable settlement, not just on behalf of Mary Blakemore, but on behalf of all public housing residents in suburban Cook County, because as a result of the settlement, the Housing Authority agreed to train all of its property managers on the laws that they had violated, including VAWA and the Fair Housing Act. And so it's an incredibly powerful tool that we've used successfully several times in the past.
I'm curious as to whether, my top 5 most abusive landlords, I'm sure that you could identify right now the worst landlords in Chicago. And I'd be curious as to whether or not, using social media like Twitter, LAF posts, this month's top 5 bad landlords, retweet this, and I understand.
I'd be a little concerned about libel actions.
No, I understand, but whatever we put it, again, we can take it offline, but I'd be curious, whatever we say, we would set in a pleading.
Right.
And so, anyways, it just, the thought occurs to me, and then, wouldn't that be interesting if that became, something that people actually look at? And so.
No, we're always trying to think of new ways to use the media because, yes, landlords are subject to shame. Some are shameless, but most can be shamed. Anything else? Yes? Anna? Or Kate? Whoever.
I was just going to mention one other silo busting
Yes.
public benefits could help with. TANF has an emergency assistance program. It's not a lot of money, but it can help if there's an eviction action that has been filed to get help on the rent. It won't help with a lot, but it might be available to help.
Yeah, sometimes a lot's not, sometimes we don't need a lot. So, yeah, Anna?
I was just wondering if LAF ever works with low-income families who are facing foreclosure because of tax hikes or are facing huge tax hikes because of poor.
That would be more our consumer practice group that would do that. The consumer practice group does all of the foreclosure work. The only time we get involved in foreclosures is when we're representing a tenant who lives in a foreclosed building. But the actual owners are represented by the consumer practice group. And I think Dan Lindsay will be coming to do a training on that for you all. Anything else? All right, thanks for your time. I know it was a lot. Please. Thank you.